to the Employment Arbitration webinar. We're happy that you've joined us, and my name is Steve Holden. As some of you may have participated in our first webinar on the paid sick leave law. This is attempt number 2, and the idea is to provide clients with further information, a little more in depth than perhaps we can do with the newsletters and the blogs that we write. And we've decided to keep the webinars relatively short, to about 30 minutes. We also encourage questions that you might have, which I will attempt to pick up at the end of the webinar today. So if you look at your screen on the meeting burner that we use, the software, there's a Q&A box in the upper left-hand corner of your screen, or there should be. And if you click on that, you can type in questions that you might have as we're going through the webinar, and I'll try to address as many of those as possible at the end of the presentation. The other thing that we again ask for is any feedback that you have, both in terms of how it went mechanically, but also on topics that you'd like to hear about. Again, the whole point of our doing these webinars is to provide clients with information, and we want to provide you with the information that you want. So if you help us by letting us know what you want to hear about, we'd be more than happy to tailor that for our future webinars. We picked arbitration this time because arbitration is without a doubt the most fluid aspect of employment law that I have seen in the 22 years that I've been practicing employment law. The developments have been huge, and they have bounced around and taken 180-degree turns frequently. There aren't any brand new big developments that have happened in the last few weeks or months. There were some big developments that happened last year and in the couple years preceding that. But the reason we picked arbitration, again, because this is a service to clients, arbitration can be one of the key preventive devices that an employer can have in place. And so we want to make sure that all of our clients get versed in what arbitration is, what it can and can't do, and so that hopefully you'll be able to make a better decision about whether or not it's right for your organization and whether there are benefits that you could get out of it. So with that, let's jump into the subject matter. And I'm going to have to push the right button to move the screen. So what is arbitration, and how is it different than being in court? So really briefly, what's the difference between a typical court case and a typical arbitration? The main difference is you're going to have a different decision maker than you would in court. You're going to have a different set of rules, the rules designed primarily for greater efficiency and speed. The greater efficiency and speed is designed also to minimize costs. Anytime you minimize lawyers' hours and involvement, we all know that reduces cost. But in arbitration, you're going to have fewer procedural safeguards, and therefore you take on a little bit more risk that you get a bad decision and you can't do anything about it. In court, you can appeal and continue to appeal, hoping that you can change a bad result. And you can't do that in arbitration, generally speaking. So a typical case in court, employment case, you're going to have the lawsuit filed. We're going to file an answer or responsive pleading, and then the case goes into what we call the discovery phase, where both sides are trying to ferret out what are the actual facts. We do that by investigating and communicating with you and gathering documents and that sort of thing. We do it with the other side by serving them with written discovery, taking depositions, hiring investigators, hiring experts to analyze things, that sort of thing. After discovery, then sometimes there are motions where we try to get rid of a case on paper, like a motion for summary judgment. And and then eventually there's a trial. In court, in today's world, what happens is you get set for a trial date. You spend a lot of time preparing for that because typically speaking, in case it goes to court, there's a lot at stake. And then you show up to court and the court says we don't have a courtroom or a judge available. And so hang around here for the remainder of the day. Maybe we'll have one later. The reason that happens is because criminal proceedings take precedence over civil proceedings, and so they swallow up a lot of the judge and court time. Sometimes that can happen 2 or 3 times where you then prepare for a trial, don't get a courtroom, have to come back 6 months later, re-prepare the witnesses, etc. So it can be very time-consuming in sort of duplicating effort that you had done 6 months earlier that you have to refresh on. Our typical arbitration case, similar, initial request for arbitration gets filed. There's usually a conference. Sometimes it's just a telephone conference with the arbitrator and the 2 attorneys involved to kind of lay out a ground rules and game plan for administration of the arbitration. In court, you're following a set of rules that you go through one after another. In arbitration, you kind of set the rules to some degree with the arbitrator on a particular case. And then there was typically a discovery phase as well, although maybe more limited, and oftentimes is more limited to try and reduce costs. And then you have the actual arbitration itself where you would show up to a conference room, and instead of a judge and jury, you have the arbitrator who will listen to the witnesses, review the documents, etc. And that aspect of it is very similar to what would go on in the courtroom during the trial, but just a more abbreviated version. So that's the typical differences between those two. Well, I wanted to give you a little history on arbitration because it's relevant to deciding what you're going to do with arbitration today. And we're going to talk about implementation. We're going to talk about, try to help answer that question, is it right for you? But a little history is I think, helpful. You start from the notion of freedom of contract, right? In the U.S. Constitution, Article 1, freedom of contract. We can agree to have anything we want. If you and I agree, it's our contract. The government's not supposed to get involved with that. Well, we don't have freedom of contract, not to that extent anyways. If you go back to 1827 in Ogden versus Saunders case out of the U.S. Supreme Court, the U.S. Supreme Court says, yeah, well, the Constitution, freedom of contract, what that really means is the government can't come in after you've entered a contract and retroactively limit that contract that you have created. But the government can, prospectively, with its police powers, tell you what you can and can't have in your contracts. So we really haven't had pure freedom of contract for centuries now. But we did, going back even 20 years ago, have a considerable amount of freedom of contract when it came to arbitration provisions. And the result of that was an advantage to the employer. The advantage came in that when I would write an arbitration provision 20 years ago, it would say that there are no punitive damages available in an employment case. There was a cap on monetary damages. The statute of limitations, instead of being 2 years or 1 year, was 6 months, so that the employee might miss out on the opportunity to actually even file their claim and have it be timely. The other things that was very common would be, particularly for clients who were multi-state, is they would have their employees in California agreeing to have their arbitration handled in Texas. And you can imagine that there probably weren't a whole lot of rank-and-file employees in California who could afford to go to Texas if they wanted to arbitrate. So the things that we were able to do in contract could make the arbitration agreement considerably one-sided in advantage of the employer. The other thing is the rules were based upon commercial arbitration rules, which had been in place for decades and decades. But those rules were not designed for disputes between an employer and employee, And one of the key provisions of commercial arbitration rules is the parties split the cost of the arbitrator. The notion being that if one side is paying for the arbitrator, well, then won't that arbitrator think more kindly of that party? So if you split the fees, then the arbitrator isn't beholden to one side or the other. But as the law developed, those rules were determined to not be appropriate for employment cases. The history progressed. What we've found is what has existed is this fight, essentially, between the federal judiciary, the federal courts, and California and the California courts. On the one hand, the federal courts, under the Federal Arbitration Act, have a very strong, favorable policy towards arbitration. California, although the courts frequently talk about arbitration as with favorable statements about how it's a good alternative and how it helps relieve congestion in the courts, et cetera, the courts themselves, the judges and the decisions, have been very anti-arbitration, almost as if the judges are saying, well, we don't trust anybody but ourselves to have good decisions, and therefore we're going to very narrowly permit parties to agree to arbitration. So we've had this battle back and forth between California courts and then the federal courts and the U.S. Supreme Court, where as of late, employers have been winning and arbitration has been winning because the U.S. Supreme Court has said that the Federal Arbitration Act preempts a lot of what California and California courts have done in interpreting arbitration agreements. The other thing that's happened is that there has been an all-out attack by plaintiffs' attorneys against arbitration. In all my years of being an employment lawyer, plaintiffs' counsel have hated arbitration, and there are, I'm sure, many reasons that they would say, but I think the primary reason for it is they don't get the opportunity at a jury and what we call the runaway jury or the jackpot jury, where on facts where they just give enormous amounts of money away, and the perception that plaintiffs' attorneys have that an arbitrator is less likely to do that. Because the plaintiffs' attorneys have such a strong lobby with the California legislature, the legislature has also attacked arbitration routinely over the years. In fact, there's a current bill, AB 465, which is on the table at the legislature, which would outlaw effectively employment arbitration agreements altogether. That has been tried before. In fact, it's actually passed the California legislature but was not signed by the governor. I don't remember who was the governor at the time, but there is this real animosity in California in the courts to some degree and definitely in the legislature towards arbitration agreement. And the result of that then is there have been tons and tons of litigated cases. Every time you pull out an arbitration agreement, you say, hey, let's go to arbitration. You've got a plaintiff's attorney on the other side that's saying, no, I don't want to go to arbitration, so I'm going to fight this, and I'm going to make arguments to say this arbitration agreement is not valid, so we don't have to go to arbitration. And as a result of that, I think arbitration in the context of employment law is probably the most litigated aspect of employment law. This went on for years and is still going on today, but back in 2000, the Armendariz decision out of the California Supreme Court was sort of a bellwether case that really laid down some basic rules going forward on arbitration agreements and what had to be included and what couldn't be included to have a viable, enforceable arbitration agreement where the employee was waiving the right to go into court on claims that are based upon a statute like discrimination, harassment, and that sort of thing. So the Armendariz case basically told us a number of things that need to be in the arbitration agreement or not in the arbitration agreement if you want it enforced under California law. One is it can't be too one-sided. There needs to be a mutuality to the agreement. It needs to provide for a neutral arbitrator. Now, that should be a no-brainer, but if you go back in history there were attempts to create procedures and whatnot within an agreement that could result in something less than a neutral arbitrator. There needs to be some level of discovery, some level of fact-finding. So you can't go so efficient that there's almost no discovery. The arbitrator needs to prepare a written decision after the arbitration, which briefly outlines what the facts are that were found and why the decision was reached the way it was. The agreement cannot take away remedies that an employee might otherwise have. So, for instance, if a statute provides that an employee can get interest on a claim, for instance, you couldn't have an arbitration agreement that says, well, you can win, but you can't get interest on that. And then finally, and probably the most significant change that occurred with Armendariz is the court said the employer has to pay for all the costs that are unique to arbitration. The theory being that, well, if the employee goes into court, the employee doesn't have to pay for the judge. And so we're not going to burden the employee with the cost of the judge, in this case the arbitrator. The employer has to pay for that. And I guess they figured that the employer paying all the time wasn't going to create the bias that had created the original rule of splitting. So in any event, one of the key considerations today is that the employer pays for the arbitrator's fees if you like are renting a conference room or a hotel conference area to conduct it, that cost. But each side still pays for their own attorneys and litigation costs. So after Armendariz, the fight continued. This wrangling back and forth between the feds and the states has continued, and you have cases that go in every different direction. And because there's so many of them, you can find an arbitration case that almost says anything you want. But there are some basic things that have sort of been ferreted out over the years. First and foremost is this notion of fairness. It's actually a contract law principle of unconscionability. I didn't write unconscionability here because it's too big of a word and too hard to spell, and so I'm just going with fairness. But the law on unconscionability of contracts, and that is the primary attack for arbitration agreements today, has two prongs: procedural unconscionability. How was it entered? Was there duress? Did we put the employee in a dark room and waterboard them and then give them an arbitration agreement to sign? Well, if you do that, it's procedurally unconscionable, and so it's not going to be enforced. The other unconscionability is substantive unconscionability. What are the terms? Are the terms fair? So my example before of having a California employee forced to go to Texas to have an arbitration would be considered today procedurally unconscionable or unfair term, and the agreement falls away and is unenforceable because of that. The true law on unconscionability was a balancing of all that, but one of the dramatic things that Armendariz did was essentially say that a contract of adhesion, a sort of a take it or leave it contract, which most arbitration agreements are or frequently are, that alone made it procedurally unconscionable. So then you're just looking at the terms of the agreement. The other thing that we've known or have learned through these court battles and all this litigation is that if you just have a policy on arbitration in your handbook, you're not likely going to be able to force the employee into an arbitration. It certainly has happened, but it's much less likely than if you actually have an express written agreement between the employer and the employee. Again, mutuality, we already talked about that, but one of the things that frequently happens is that all the claims that the employee must bring are put into the agreement. But then there's nothing said about what the employer must do in terms of claims the employer might have against the employee. And there have been cases where the arbitration agreement has gone down because those are not expressly covered in the agreement. Okay? The other thing that you have to watch out for would be too onerous of pre-arbitration exhaustion requirements, things that an employee might have to do in order to get into the arbitration. So for instance, some arbitration agreements, a lot of them have a pre-arbitration mediation. The notion is, can we work this out in some compromise in a meeting before we go into the litigation of arbitration? And that's still fine to have a mediation provision, but if they're too onerous or too costly for an employee, they could then upset the enforceability of the agreement. Some other things, rules of arbitration, are they defined and provided to an employee? All the ways that plaintiff's attorneys have attacked the agreements would be, hey, wait a minute, you didn't provide rules to the employees. How did they know what they were agreeing to when they agreed to this? The alternative to that is, well, you provided them with 50 pages of rules. That's so complicated. How could they ever know and not be confused by that? So one of the considerations is, are you going to provide rules? Which rules are you going to use? How are you going to provide that to the employees? All part of the consideration of how you structure your own arbitration program. We know you can't prohibit an employee from having an attorney represent them or another kind of representative. You can give the arbitrator authority to determine the enforceability of the agreement. And oftentimes that's a very good idea because we're trying to limit the court's involvement with arbitration. But you have to be careful there too and have your eyes wide open because there was a case where an arbitrator decided, yes, this class action is subject to arbitration, and the class action has to proceed through the arbitration, which means it didn't get rid of the class action, it just moved it from court into arbitration, which then, since you're paying by the hour for the arbitrator, you can imagine how many hours that arbitrator just made for themselves by ruling that way. The other thing to consider is, what's the law, where are you going to have it? Those are considerations for multi-state employers, and again, trying to make sure you don't have your agreement thrown out because of substantive unfairness. Okay? Another key thing that's been litigated over the years is the scope of what's included. Can you include administrative claims like workers' comp, unemployment, wage claims with the Labor Commissioner, claims of discrimination and harassment with the DFEH, the Fair Employment and Housing Commission, or the EEOC? Recently, there was a Sonic case which made it very clear that you can, in the case of wage claims, have them waived and submitted to arbitration. But it begs the question, in many cases, the advice we would give is, well, you really don't want to take every claim and put it into arbitration because you've got the cost of the arbitrator. And if you already have a mechanism through the Labor Commissioner or the DFEH for resolving disputes at an administrative level, oftentimes you can do it there more efficiently and more effectively than if you were to pull that out and take it to arbitration. So it's one that, you want to talk through about what's going to be best in your situation. And again, in terms of employer claims, originally what we tried to do was exclude everything that we wanted from an employer standpoint to take into court. You can't do that anymore. So you have to consider, well, okay, what kinds of claims might I have against an employee? And if so, am I going to be successful with that in arbitration, or do I need to be in court for that? So class actions, this was over the last 5 or 8 years the biggest battle, because class actions, as you know, in employment law have been huge. So we've tried everything we can to keep them, to put a limit on them, if you will. And what we know out of big cases from California and the United States Supreme Court is that the feds are winning that battle, and they have essentially said that class actions can be waived. So we can put in an arbitration agreement, the agreement that an employee will not bring or participate in a class action. We know that because of the AT&T Conception case out of the United States Supreme Court, which was then followed up by the Iskanian case out of the California Supreme Court, I think it was last year. Now, I have a little maybe there, a small maybe, and that small maybe is just a reminder that individual courts have gone in every different direction when it comes to the day-to-day enforcement of arbitration agreements. So you might still decide you're not going to use a class action waiver, even though we have very favorable case law on it now because of just the variances of individual courts. The one thing we also know currently, though, is that PAGA claims, Private Attorney General Act claims under California, which is a way that plaintiffs' attorneys are bringing wage and hour claims, cannot be included in an arbitration agreement according to the California Supreme Court. I have a bigger maybe here because the federal courts in California have said, well, we don't think the California Supreme Court is correct on that, and we are going to permit the waiver of PAGA claims when that arbitration agreement is in federal court. So what's going to happen is one of the considerations in whether you're going to have a class action waiver or not is what court do you think you're going to be in, okay? So that's one of the considerations for class actions. Are you more likely to be in federal court, or are you more likely to be in state court on a claim? And if you're in federal court, then you may well decide to take the PAGA claim and include it and try and waive those as well. If you're going to be in state court, you're less likely to do that because you don't want the inclusion of a PAGA waiver to invalidate the entire agreement and you don't get into arbitration at all. So the primary consideration for class actions would be venue, where are you going to be? The other consideration would be how many employees do you have? And what kind of industry are you in? Are you more likely to face a class action, or I should say, how likely are you to face a class action versus an individual employee claim? And so that's one of the things that we talk through when we're trying to decide what's going to be best for you. So another quick note for federal contractors. Last year, President Obama passed an executive order which essentially says that federal contractors cannot require employees to arbitrate disputes of Title VII discrimination claims, sexual assault, or harassment claims. So if you're a federal contractor, you're going to need to watch out for that in terms of how you structure arbitration if you have arbitration. So is arbitration right for you? Okay, so this is the checklist of things to consider when you're thinking about the arbitration for your organization. Jury verdicts. Probably the primary thing people think about is, I don't want to be in court. I can't control a jury. There is some validity to that because I can tell you from experience, most of the people who are on juries are not managers, business owners, human resource professionals, and they tend to be people who are on the other side. They are employees or retired employees. And so they're much more likely to be able to put themselves in the shoes of the employee than they are the manager, the supervisor, the company president, the HR director, etc. So there's this notion that you'll start with a delayed start, or that the employee has a head start if you have a jury verdict. So I don't want to be in court. I want an arbitrator. Arbitrators tend to be retired judges, sometimes attorneys who've been practicing a long time, who maybe are more likely to be able to put themselves in your shoes. Efficiency, time, and money. So the whole thing I already described, how a court case goes and how you might come up for your case 4 times before you actually get out, and that's extremely expensive, and the procedural hoops that you have to go through, extremely expensive and time-consuming for us lawyers to comply with. So if you go arbitration, let's get real, let's have some efficiency to this, let's just get to the bottom line. That's all good from a money standpoint. The more you can limit lawyer time, the better. The only downside of those efficiencies from arbitration is you give up some of those procedural safeguards, like the right to appeal if you get a bad decision, and you can get bad decisions from an arbitrator. Privacy used to be, and still is, I guess, to some degree, a consideration. If you have a court case, it's a public record. newspapers can pick up on it, and you can have publicity that you don't want. Arbitration has always been a private forum where you don't have that. Unfortunately, last year the legislature passed, I think it was 802, AB 802, which now requires arbitration companies like the American Arbitration Association, JAMS, etc., to publish publicly the arbitrations that they're handling and the details of those, including the participants in that. So the privacy is not going to be what it used to be in terms of a consideration, but still maybe more private, given that that's a new requirement than the court cases. Then you have the perceptions of how will the employees view this. If you have an older workforce who can remember the days 20 years ago when arbitration agreements were wildly one-sided, and you roll out an arbitration agreement today, they may think, what are you trying to do, take advantage of me? And it could lead to negative perceptions. And we'll talk, when we talk about implementations, about strategies for avoiding that. The other thing to consider is the realities of an arbitration agreement. They can be extremely powerful as a preventive tool. And I'll give you an example of something that has happened on more than one occasion in my career, but not something you can guarantee. We get a demand letter from a plaintiff's attorney saying, you dirty, rotten employer, you harmed my client in this way and that way and that way, and give us $1 million or we're going to sue you. And then we send back a letter saying, okay, well, before you sue us in court, here's a copy of the employee's arbitration agreement. So if you want to go forward, let us know and we'll move forward with the arbitration. And then we never hear another peep from the attorney or the employee. That's happened more than once that I've been involved in. Now, again, can you guarantee that? No. But if you could get that result, it's a good result for sure. So there are those realities that come from the fact that plaintiffs' attorneys still to this day hate arbitration. And even if they don't run away like that, the value of the case for an early settlement oftentimes is considerably less with the existence of an arbitration agreement. So that's a consideration as well. So implementation, let's talk about that briefly. One of the things to consider is, will you implement it for all your employees, or might you just do it going forward for new employees that come in? If you do it with your existing employees, what issues might exist there? What perceptions might they have, and how are you going to deal with that? We certainly have clients that don't do it with all employees. They do it with categories of employees. So it just depends. I think most of our clients do all employees, including current and new, but that is a consideration, and particularly how you set up the initial drafting. And you're going to want to have a well-written agreement, and I don't just mean, well-written in the terms of sentence structure, etc. I mean carefully thought through in terms of how you want it to work in accordance with what law we have that we talked about earlier, but then also what's right for your organization. And you want to make sure there's nothing in there that is going to, again, have a court or an arbitrator say, I'm not enforcing this because you've got this provision in here, and so I'm tossing the whole thing out. Okay? A communication strategy. Before you roll it out, you want to have a plan in terms of what you're going to communicate to the employees. Why are we doing this? What is the value of it? Again, going back in time, employees could say, well, you're just doing this because you want to take advantage of me and you want to strip me of my rights to go to court where that's the only safe place for me to be. We need, in the communication strategy, to get employees to understand that in today's environment, all you can do is move from the court system to the arbitration. You can't take away rights. You can't play the tricks of no punitive damages or short statute of limitations. You're just moving to a forum that is designed to be more efficient. And there are considerable benefits to employees to be in that forum as opposed to the court system, and helping them understand that and understand that the value of everybody spending less money and time with lawyers is beneficial.
review time. If one of the things that can disrupt the enforcement of an agreement is if you, again, don't give somebody the time to actually review it, consider it, maybe talk to their attorney or representative or family about it. So you'll want to build that into how you roll it out for sure. And then follow up and further communication. So typically we recommend that you have some sort of a initial communication employee meeting where you're discussing the benefits, discussing the intent of the company in utilizing arbitration and the mutual benefits of it, and then give it to the employees to consider and have them then return them. You obviously want to follow up to make sure you get the signed agreements back, but it may also be a further opportunity for education, because if an employee doesn't return it, it may be a sign that they are hesitant or they're skeptical or they're suspicious or that sort of thing. It gives us the opportunity to say, hey, I haven't got your agreement back. Hey, what's up? And initially they might not say they're skeptical, but if we're open enough and we have good communication, hopefully they do, and that gives us another opportunity to try to educate them that it isn't this one-sided thing anymore in today's environment. And the other thing to consider for existing employees is if somebody really, really doesn't want to sign it, well, you could decide to say, okay, and empower them to get it their way, because if you don't have an arbitration agreement with them today and you don't get them to sign the new one, you're in no worse position than you were before. So that's a consideration as well. And then finally, how are you going to maintain those records? Where's it going to go? Is it go in the personnel file and the typical stuff with personnel files? Is it safeguarded, etc.? I've had on several occasions litigation come in. Client says, "Well, we have an arbitration agreement with this person." I say, "Okay, great. Send over the arbitration agreement," and then they go look for it and they can't find it. So again, if you're going to go to the trouble of rolling this all out, then you want to make sure you have a strategy to make sure you have a copy of that agreement when you need it. So that was as fast as I could go through it, and I realized that it's actually a little longer than the 30 minutes. I apologize for that. If anybody has any questions, certainly let me know. I don't see any questions currently in the Q&A box unless I'm missing something. I hope that's not the case. Given that you're all clients, though, if you do have a question, feel free to just send me an email. I'll be happy to. Oh, we do have one. Why would I not want to have such agreement in place? That's a good question, and in today's environment, with the cases that have come down in recent years, and my personal experience with arbitration agreements, I would say I encourage every client to have one. I think the benefits outweigh the negatives. I think the employee morale issues that could exist are very solvable with a good communication strategy. And one of the things that I failed to mention as one of the practical realities, and I should have, is this happens not infrequently. We have an arbitration agreement with an employee. We get the demand letter from the plaintiff's attorney saying, "I'm going to sue you." It doesn't say anything about arbitration because the employee forgot they signed one, or they didn't tell their lawyer they signed one. And the reality is, at that moment in time, we ultimately, the employer, get to decide, do we want to do arbitration or don't we? And if at that moment in time, for whatever reasons, we think arbitration is not in our best interest, then we just keep our mouth shut that we have an arbitration agreement, and we go to court where the plaintiff's attorney wants to go anyways and thinks that he's supposed to go. So very often you actually end up with sort of an option at the moment in time. Now, again, you can't guarantee that, because if they come and they say, "I want my arbitration," you've got to go. You've got the signed agreement. But not infrequently, we actually have sort of a choice. So that's another benefit to having them, in my view. Hopefully that answered that question. Well, again, thank you for participating, and if you have any suggestions for topics, if you like the webinar, if you hate the webinars, tell us, and we'll stop doing them. because this is all designed to try and give you guys service and things that can be beneficial for you. And you can send emails to me. You can send emails to Melissa Johnson in the office. You can just send an email in through our website. However you want to communicate with us, you can call us. Again, we appreciate you as clients and want to make the service the best we can. And I apologize for going late, but you let a lawyer talk, and this is what happens. So I wish you all a great rest of the week, and thanks again.